Good day, my name is Hani Nashahrina and today I'm going to present our group's legal analysis about a cross not negotiable check that was fraudulently altered and used. This case is a very good example of how the Bills of Exchange Act 1949 protects the true honest rights when fraud happens in a financial transaction. Here's a background of the case. Hyun Bin crossed a Rm 10,000 check payable to Sedapah Sendirian Berhad and marked it not negotiable. This means the check should not pass a better title than the transferor. Then, Won Bin stole this check, chemically erased the payee's name, and put his own name instead. He then used it to buy a television from Minho. Minho later deposited the check into his account at Jota Bank. Later, when Hyun Bin demanded the Rm 10,000 back, Minho refused. So, we have two main legal issues here. The first issue we need to resolve is whether the material alteration made by Won Bin makes the check void against everyone except him. According to Section 64 of the Bills of Exchange Act 1949, a material alteration made without consent makes the check void against all except the person who made it. This principle was explained in Viswanathan v. Somasundaram 1960. Here, Won Bin chemically changed the payee's name without Hyun Bin's consent. So, the check is void against everyone except Won Bin. Hyun Bin is discharged from liability and the bank should have noticed this fraud and not cashed the check. This shows us the importance of consent and how fraud can affect financial transactions. The second issue we need to arise is whether the not negotiable marking prevents Minho from acquiring a better title than Won Bin. According to Section 81(1) of the Bills of Exchange Act 1949, a cross not negotiable check cannot pass a better title than the person who transfers it. This principle was upheld in Gordon v. London City and Midland Bank 1902. Here, Won Bin stole and altered the check first. This means his title was faulty from the start. So, when Minho received it, even though he acted in good faith, his title remained faulty. Therefore, Hyun Bin has the legal right to get back the Rm 10,000 from Minho. This highlights how a cross not negotiable marking protects the true honest right. To conclude, we have two main legal issues here. For the first, the material alteration made by Won Bin makes the check void against everyone except him. For the second, the not negotiable marking prevents Minho from acquiring a better title than Won Bin. Therefore, Hyun Bin is legally allowed to get back his Rm 10,000. This shows us the importance of consent, vigilance, and protective measures in financial transactions. Thank you for listening.
Hello, my name is Alysa Jelius, and for the next part, I will be presenting the scenario 2, forged check and bank negligence under Malaysian banking law. Okay, for the scenario summary, in this situation, Won Bin came across Hyun Bin's blank check, which had not been signed and marked account pay, and instead of returning it or reporting it, Won Bin decided to forge Hyun Bin's signature, write the amount of 15,000 ringgit to and insert his own name as the payee. He then brought this fraudulent check to Rupa Bank, and the employee, Mr. Lazi, noticed that the signature appeared suspicious, but he chose to proceed and cash the check anyway. And once Hyun Bin discovered the unauthorized withdrawal, he filed a lawsuit against Rupa Bank, and this incident gave rise to two important legal issues. The first issue is whether Rupa Bank is subject to Malaysian law for accepting a check bearing a fake signature. More specifically, does the bank have a right to debit the customer's account when the check was not genuinely authorized? To answer this, we look at Section 24 of the Bills of Exchange Act 1949. This section clearly states that any check containing forged or unauthorized signature is void and inoperative. In simple terms, this means that the bank has no legal right to withdraw money from a customer's account based on a such check. This legal principle is supported by the Malaysian case Malayan Banking Berhad v. Muhammad Rofi bin Mohamed, where the court that held that when a bank processes a check with a forged signature, it is acting without the customer's authority and must be held responsible for any loss incurred. So, in application, we apply this rule to our scenario. It is evident that Hyun Bin never signed the check, and he never authorized the withdrawal. The check was entirely filled out by Woon Bin, including the forged signature. Rupa Bank should have verified the drawer signature carefully, but instead it ignored the warning signs, and importantly, there is no indication that the Hyun Bin was careless with his check or contributed to the forgery in any way. Therefore, Rupa Bank has no legal authority to process the transaction and debit Hyun Bin's account. In conclusion, for issue 1, based on the section 24 of the Bills of Exchange Act and the legal precedent in the Malayan banking case, Rupa Bank is legally liable for the 15,000 ringgit that was wrongly debited from Hyun Bin's account, and the forged signature makes the check void, and the bank acted without proper authorization. Rupa Bank is therefore required to reimburse to Hyun Bin. Now, we move on to the next legal issue, which is, did Rupa Bank breach its duty of care by processing a suspicious check, especially after Mr. Lazi, the bank employee, admitted that the signature didn't look right? Banks in Malaysia are required by common law principles and banking standards to exercise reasonable care and skill when handling their customers' account. This duty includes carefully verifying signatures, especially when they seem questionable. If a bank fails to act prudently and this failure results in loss to the customer, and bank can be held liable for negligence. In this case, the evidence of negligence is very clear. Mr. Lazi, the Rupa Bank employee, noticed that the signature looked very suspicious, but despite this, he did not take any action to verify the authenticity of the check or refer the matter to a supervisor. Instead, he proceeded to cash the check and allowed 15,000 ringgit to be withdrawn. This behavior demonstrates a clear breach of the duty care. A reasonable and careful banker will have taken steps to investigate the suspicious signature before proceeding. Rupa Bank failure to act on these red flags directly led to the customer's financial loss. In conclusion of issue number 2, Rupa Bank breached its legal duty of care by ignoring the suspicious nature of check. Its action, or rather its failure to act, amount to negligence. As a result, the bank is legally responsible not only under the Bill of Exchange Act but also under the negligence law. The RM 15,000 should to be returned to Hyun Bin. To summarize, this case involves both a forged check and a failure by the bank to exercise due care. Under the section of 24 of the Bills of Exchange Act 1949, the forged check is void and Rupa Bank is not permitted to debit Hyun Bin's account, and furthermore, under the common law duty care, the bank acted negligently by processing a suspicious check without verification. Therefore, Rupa Bank is legally liable and must compensate to Hyun Bin. That's all from me. Thank you.
Good day everyone, I'm Bryan Soo and my metric number is BB22110945. Today I will present a case study titled A Liability of a Bank for Collecting a Stolen and Altered Check. So let's begin with a legal issue raised in this situation, whether Rupa Bank is liable for negligence and conversion for collecting a stolen and altered check deposit by a third party without conducting proper verifications. So this question goes to the heart of bank duty of care and whether it has fulfilled its legal responsibility to verify customer identity and protect the true owner of the check. To analyze this issue, we refer to three main legal sources. Number one, Bill of Exchange Act 1949 BEA under Section 4, Subsection 1. A check is a bill of exchange drawn on a bank and payable on demand. Under Section 85, Subsection 1, a collecting bank is protected only if it acts in a good faith and without negligence. Main legal sources number 2 is conversion, tort law. Conversion is wrongful interference with another person's property. Collecting a check for someone not entitled to it may constitute conversions. Number 3 is AMLA 2001 and BNM AML CEFT guidelines. These require bank to conduct KYC, which is Know Your Customer process, and bank must identify, verify, and monitor clients, especially during account opening and suspicious transactions. If a bank fails to comply with this, it may be civilly and regulatory liable. Case law gives us important judicial guidance. Number one, case law number 1, Tay Chia Chun v. United Overseas Bank 1987. The bank was held liable for collecting a check for someone with no title. The court emphasized due diligence is essential to avoid liability. Case law number 2 is Malayan Banking BHD v. Hashim bin Hassan 1994. A forged check collected negligently was ruled as conversions. The bank failed to verify and was held responsible for wrongful interference. These cases show that bank cannot act carelessly in check collection. They must actively verify customer and check for the red flag, especially in high value or suspicious transaction. Let's apply the law of our scenario. Robert, the employee, stole his employer Roberto checks and altered the payer name by removing the O from Roberto, making it look like it was payable to Robert. He then went to Rupa Bank, opened a new account, and deposited the check worth 2,000 ringgit. Miss Jana, the bank officer, accepted the check without checking Robert's identity or questioning the close similarity between the names Robert and Roberto. This lack of verifications amounts to gross negligence. The bank ignored suspicious signs, the accounts was new, the name manipulations was obvious, and no proper KYC, which is know your clients, was conducted. And robber bank lost protections under Section 85, subsection 1 of the BEA and committed conversion by handling a check belonging to someone else. It also breached AMLA and BNM KYC obligations. Let's now recap what happened in this case. First one, Robert, an employee, took a check issued to Roberto. Number two, he altered the pay name from Roberto to Robert. Number three, he deposited the check into a newly opened account at Robert Bank. And number four, the bank officer, Miss Jana, failed to verify identity or investigate. And the last one, Roberto discovered the fraud and lodged a legal complaint. So this summary highlights the bank procedural failure and how Robert successfully manipulated the system due to the poor verification protocol. In conclusions, Ropa Bank is clearly liable for both negligence and conversions. It failed to act in a good faith and was grossly negligent. It collected the check for someone who had no right to it. It violated Section 85, subsection 1 of the Bill of Exchange Act. It breached its duty under AMLA 2001 and BNM KYC regulations. As a result, Roberto has strong legal grounds to recover the 2,000 ringgit Malaysia. This case emphasized the critical role of due diligence, KYC compliance, and risk awareness in banking operations, particularly when processing checks or onboarding a new customer. Thank you.